This program is brought to you by Emory University.
Good evening, ladies and gentlemen. Welcome to Emory University School of Law and tonight's panel discussion, The Future of Marriage and Family Life. My name is April Bogle, and I'm the Director of Public Relations and Information for the Center for the Study of Law and Religion. We are the host of this evening's session. The Center for the Study of Law and Religion is a research center dedicated to exploring the religious foundations of law, politics, and society. We focus on how the teachings and practices of Christianity, Judaism, and Islam have shaped and continue to transform the fundamental ideas and institutions of our public and private lives. Our faculty provide the latest perspectives through their published works and lectures, while our conferences and forums foster reasoned and robust public debate. Tonight's event promises such a debate as we examine some of the most contentious family law issues facing courts and legislatures today. Should states offer a covenant marriage option? If so, what other options should be considered? Same-sex marriage? Polygamy? What role should the church versus the state play in making such decisions? Should same-sex couples be restricted from adopting children? What rights should children have in ugly divorce custody battles? Should we do away with legalized marriage altogether? These are among the many important topics to be discussed tonight. Volumes of information on these subjects, literally, are available here this evening. Books recently published by our speakers are on display just outside the auditorium. And now I would like to introduce tonight's moderator, John C. Mayu. Mr. Mayu is an esteemed alumnus of Emory University School of Law. A partner in the domestic relations litigation firm, Warner, Mayu, Bates, and Nolan, Mr. Mayu has been described by the news media as the go-to guy for divorces of high-profile couples. Remember Ted and Jane? Newt and Marianne? Remarkable couples with remarkable stories, all handled with remarkable grace once Mr. Mayu had been signed on to handle their cases. In addition to his legal practice, Mr. Mayu is the author of 5 books on family law and numerous nationally published articles on topics such as artificial reproduction technology, privacy interests, non-marital cohabitation agreements, third-party claims, and the legal status of step-parents. His commentary on family law issues has been featured in national news magazines and newspapers, as well as on all major cable and television networks and national public radio. Mr. Mayu is a fellow of the American Academy of Matrimonial Lawyers and is listed in the best lawyers in America. Please join me in a warm welcome of John C. Mayu.
Thank you, April. Good evening. There has been extensive, biting commentary by prominent social scientists, theologians, and politicians regarding the precipitous decline of the American family, stinging criticism of the very state of marriage. At an international congress held in London, England, the question posed to the sociologists present was, "Abolish family?" ? The conclusion drawn was that the family was a, quote, worn-out social unit that would inevitably dissolve under societal pressure. A prominent American magazine published a feature entitled The American Family, in which it observed, quote, "The United States family, deep in the mill race of social and technological change, is itself in deep trouble." An article in Science Digest concluded, quote, "The decline of the American family is as serious as it was in ancient and now fallen Greece and Rome." Social scientists point, in part, to socially repugnant negotiations regarding the very entry into the state of matrimony, the so-called prenuptial agreement, as the embodiment of the lack of loving and permanent commitment upon the entry into the former sacrament and now contract of marriage. In some cases, parties enter into these agreements overtly anticipating the bad behavior of their spouse. In one such case, the wife agreed that she would suffer a financial penalty if she ever committed adultery. The husband would also suffer a similar financial penalty, but not for a singular indiscretion, a so-called one-night stand. There would be no penalty in that regard for the husband. A selected panel of their neighbors would determine the guilt of the husband or the wife, a so-called adultery arbitration panel. The International Congress that posed the question, abolish marriage, was held in 1949. Life magazine and Science Digest published their articles in 1947. And we only recently began to discuss this repugnant prenuptial agreement because you see it was written in hieroglyphics in the year 300 BC. Discourse regarding the future of marriage and family life is certainly not new. The criticisms expressed that I've just repeated to you were done at a time where divorce was virtually non-existent. Out-of-wedlock birth rates were very low or not reported. And the traditional family structure that we understood as Americans was a husband and a wife with biological children born as a result of that union. That was the overwhelming majority of United States households. On October 16th of 2006, it was reported that for the first time in United States history, traditional marriage has ceased to be the preferred living arrangement in the majority of United States households. Of 55.8 million households in the new majority, 14 million are headed by women, 5 million headed by men, and 36.7 million by a category described by the government as, quote, non-family households, end quote, a pejorative term to many. Since this outcry of the 1940s, the divorce rate has risen from less than 0.5% to over 60%, the unmarried birth rate to something virtually unreported to 37%. It is estimated that there are 22 million children in the United States who do not have two married parents. It is furthermore estimated that there are some 8,800,000 children in this country who have no contact whatsoever with one of their parents. The new American family includes terminology and concepts that were until recently unknown. We have same and opposite sex couples raising natural and adopted children, parents that have no genetic relationship to their children, psychological parents, parents by estoppel. We even have in this country today intended parents, persons who have certain conduct toward children who they are not related to, but they are now deemed to be their parents. When one famous politician opines that he is for family values, one might reasonably reply, what could that possibly mean? How would you define it? Many question if there remains a state interest in marriage or family life, and if so, what is the public policy of the state in that regard? What roles have traditional societal institutions, such as churches, synagogues, civic organizations, have in this debate? And what roles have they taken, and what roles have they forsaken? What political forces are now to be reckoned with, from ballot initiatives to legislation that allocates financial benefits depending upon marital status and cohabitation status? And finally, we ask, how has the very purpose of marriage changed from the traditional construct? Is marriage as historically understood and family life as historically practiced either viable or socially desirable? To discuss the future of marriage and family life, I am proud to introduce Anita Bernstein, who is the first Sam Nunn Professor of Law at Emory University. She also serves as the Wallace Stevens Professor of Law at New York Law School. She's a nationally recognized scholar in numerous areas such as feminist jurisprudence and torts, and she has wide-ranging scholarly interests in the law. She is the editor of Marriage Proposals, Questioning a Legal Status, and many widely cited articles. Mark Jordan, who is seated to her right, is the Asa Griggs Candler Professor in the Department of Religion at Emory University. His research interests include the history of Christian teachings on sex, the relationship between Christian theology and power, and issues of homosexuality in Christian churches. Professor Jordan is the author of numerous articles and books. Among his most recent books, Authorizing Marriage, Canon, Tradition, and Critique in the Blessing of Same-Sex Unions. Professor Jordan has won numerous awards for his teaching and research, including a prestigious Guggenheim Fellowship. Seated next to Professor Jordan is John Whitty, Jr., who's the Jonas Robichaud Professor of Law and Director of the Center for the Study of Law and Religion at Emory University. He is a specialist in legal history, marriage, and religious liberty, and he has published 120 articles and 19 books, including Covenant Marriage in Comparative Perspective, Family Transformed, Religion, Values, and Society in American Life. He has 7 other books under contract. Professor Whitty has been selected 8 times by the students at Emory University School of Law as the most outstanding professor. And seated to his right is Karen Worthington, who is a Barton Fellow, founding director, and current co-director of the Barton Child Law and Policy Clinic at Emory University, where she serves as a clinical professor and teaches child advocacy. She specializes in both child welfare and juvenile delinquency concerns. She is the editor of Georgia's Responsibilities Toward Children in Foster Care, which was published in the year 2005. Our first distinguished panelist, Professor Bernstein, will make her presentation now.
Thank you, John, and I am delighted to be here and welcome you to our forum. We 4 speakers have selected particular topics to address individually, and we also will, as I think will emerge, have overlapping interests and themes in common that will become clearer later. My own agenda for today, in about 7 minutes, is to talk about the relation between law and marriage. And in particular, I have been assigned the topic of abolish marriage, ? That April and John have referred to. I don't want to get right to that idea immediately. It's not a winning idea. It isn't likely to happen, and I don't, in fact, endorse it. But in order to situate the proposal of abolishing marriage, I need to sort of say a bit about what it is and then talk about what is going on in the real world with respect to legal change relating to marriage. What I mean by abolishing marriage, and there are different interpretations of the phrase, would be for the state to abandon its recognition of marital status so that couples would form and they would often have their unions celebrated in their communities by whatever devices and rituals they choose, but the law would have no category of marriage and would not acknowledge a legal relationship between these 2 adults. That's the proposal. Again, DOA, but I'll come to it in a more modified form. What really is going on with respect to marriage and the law these days? I would think the number one topic, you can probably guess what it is same-sex marriage. Very, very important and filling all branches of government in the United States today, as well as the popular media. The idea that a couple should be permitted to marry in the eyes of the law, even if it consists of a man and a man or a woman and a woman, is a relatively recent realistic political development. So related to same-sex marriage are 2 ancillary categories. The resistance to same-sex marriage, taking form now in a drive to create a constitutional amendment that would not permit same-sex marriage. Also related to that is Congress's Defense of Marriage Act of 10 years ago, saying that under federal law, marriage must consist only of a man and a woman. and also the lesser versions of same-sex marriage that have become popular at the state level. The most famous of those is civil unions, but we have around the United States domestic partnerships and lesser municipal recognitions where people can sign up for some, though not all, of the benefits of marriage in their own state. These are the two, or rather, this is the main topic, I think, in what's going on now in changes and discussions of change in American law. The second topic in popularity, and it's a distant second, I think it's much less significant, is the role of government as an affirmative, energetic proponent of marriage in welfare policy, for instance, imposing rewards to couples who choose to marry, disincentives to those who would not marry. Covenant marriage, which we have heard about, is a way for the state to install a more permanent, harder to get out of union as an option that a couple might choose. What are these two trendy, important, much talked about, much ballyhooed new legal developments have in common? That the government is affirming marriage as a good thing, and that people who are participating in these debates are agreeing that marriage is desirable. Same-sex couples seek it out. Resistance to same-sex marriage seeks to defend marriage, that's the word used in the statute, from the harms of the same-sex availability. And the government promoting marriage is a vote in favor of marriage as a way to order one's life. So I can hear the duh out there. I mean, imagine what more could government be doing on marriage? Or how else could government take a view of marriage other than a positive, affirming, and encouraging attitude? Well, if you go back, 30 or 35 years, the top two trends in marriage were very different. I would say number one, 35 years ago, was the rise of no-fault divorce, spreading from California starting in 1971. And the second development, which John has mentioned, is the decision of judges all around the country to agree that prenups are enforceable, that you can make a contract before your marriage about how your property will be divided when the marriage ends. Courts used to despise those agreements, refuse to hear them, refuse to allow any enforcement, and now all around the country they are accepted. And I think, as John indicated in his remarks, that's not a pro-marriage stance. I think you can argue, you can say, well, prenups are good for marriages, they encourage discussion, they result in a happier union, they weed out people who don't want to be married anyway. But I think those two developments of the old days, of the 70s, are not the kind of affirming and cheering sort that we see now on the policy table. This brings me to the idea of abolishing marriage. So my thesis that I want to throw out for discussion is this. It is possible that this enthusiasm for marriage is misguided and that the government should stop endorsing it so heartily and instead take a more neutral attitude toward the decision of two people to be married, not getting in their way, but not bribing them, touting marriage, promoting it, and otherwise putting a thumb on the scale as couples make this very intimate decision, perhaps a very private one, in ordering their own lives. As I have said a couple of times, the government is not about to abandon its recognition of marriage, but there are some lesser versions of the reform that you might be willing to entertain if you were king, if I were, things we could do differently. We have, for instance, in the United States, the option of a joint marital income tax return. That's not the way it happens in most of the other wealthy countries of the world. In the OECD, I think it's only about 10 or so out of 32 countries have even the option, let alone the encouragement of filing a joint marital tax return. We could withdraw our concern with a spouse's income in determining Social Security benefits so that a widow, for instance, or a divorcee would not be collecting Social Security based on the amount of qualified earnings that her husband accumulated while he worked. We could abandon the Internal Revenue Code's decision to treat the furnishing of spousal health insurance as a non-taxable event. Right now, if you're on a matrimonial kind of policy, if your spouse is the one who's insured and you're getting health insurance, the federal government says that's not income to you, so you don't have to pay taxes on it. That encourages employers to create health insurance on the job for spouses. Domestic partners do have to pay taxes on the benefit of the health insurance that they get, so the government could weaken its support of marriage by abandoning this tax break for marital health insurance. The general message of these changes would be to, I think, improve some aspects of both of those two trendy events that I mentioned. If the government cared less about marriage, did not promote it so actively, and heartily as it now does. I think we might see an improvement in the same-sex marriage fight, and we might see better government policy the lessons we learn about marriage from our government. If the consequences, and I'm thinking mainly about financial ones and legal ones because that's just my lawyer bent, if those consequences were reduced, if it mattered less that you were married for purposes of your income and whether you were healthy and had other financial advantages, then I think the fight over same-sex marriage grows less bitter. Right now, it's an extremely divisive issue. We've got the country split about 50-50, half supporting civil unions, half not, a much more skewed vote on whether same-sex marriage should be allowed. But when that battle does exist, even though the advocates of same-sex marriage are in the minority, it's quite acrimonious and painful. So I think if we could reduce some of the emotional hurt that's associated with this fight, we would be doing a good thing for the world. If the expense that the government engages in order to promote marriage could be reduced, there would be a savings in government money. We're now spending hundreds of millions of dollars a year on federal marriage promotion efforts. We may have something better to do with the money. Covenant marriage is costly to install, tough to get through legislatures, cumbersome to work out through compromise. All of these things are not free. They may appear romantic or love-affirming, but they actually have a price tag. And so what I would hope to discuss when our floor opens up to you is whether the government should be promoting marriage so enthusiastically as it now does, and how we might be better off with a more neutral attitude toward the choice to be married.
As the only non-lawyer on the panel, I think I meant to offer a musical interlude. And coming after Anita, I always feel so mild. Religious traditions hold contradictory notions about marriage. What could be more obvious, or it seems, more difficult to remember? For example, anyone who says that marriage has always involved one man and one woman for the last 6,000 years, or 5, or 3, has forgotten the history of religions, including the history of ancient Israel, as recorded in its scriptures, which Christians called the Old Testament. But religions also evidently disagree about how their marriage rights or regulations should be related to secular law. In not a few religious traditions, there is ideally no distinction between religious community and civil government, so that the category of secular law constitutes heresy or unbelief. Let me presume that most Americans still want to continue our experiment in religiously tolerant democracy, and let me restrict my comments to Christian churches, since I study them for a living and since they are the most vocal contenders in American debates. What role ought churches to have in setting marriage policy? The first thing to notice is that current fights over marriage are fights among Christians. Debates over same-sex unions, for example, cannot be described as believers against unbelievers, Holy Scripture against godless liberalism. There are believers on both sides, Scripture on both sides, and now whole denominations on both sides. When Georgia forbids same-sex marriage, it denies the religious belief and worship of a growing number of churchgoers. This fight within Christianity is not going to go away. It is part of a long historical trend. Most parties in the debate over same-sex marriage forget how far major Christian denominations have altered their views in the last 80 years on divorce, remarriage, contraception, women's roles, and legitimate sexual activities within marriage. No Christian church now teaches exactly what it taught about sex 100 years ago. Traditional or evangelical authors currently advocate marital acts that would have made the most dissolute Unitarian of 1900 blush deep crimson, and that would then have risked criminal prosecution in many jurisdictions. The historical trend is, of course, much longer than a century. It reaches back to quarrels over marriage and celibacy in the Reformation, and beyond them to deep instabilities in original Christian teaching about marriage. The quarrels among Christians are not going to stop. They never have. I often wish that Christians might debate these issues without interference from the state, and without one churchly camp or the other relying on the state's coercive power. Christian ministers should refuse to act as agents of the state in blessing any kind of marriage union, as they should not be agents of the state when they baptize or consecrate the Eucharist. Since I support the noble experiment of religiously plural democracy, I also believe that so long as the state distributes citizen benefits through marriage, it is obliged to strive for a religiously neutral civil marriage. To be religiously neutral in our present historical moment, civil marriage must be flexible as to the number and gender of the parties involved in it, its conditions of dissolution, its relations to reproduction or child-rearing, and so on. Stated in this way, my wishes for a trial separation between churches and civil governments around marriage are not predictions so much as utopian fantasies. They break down in important ways on contact with confusing historical reality. Let me name just two related confusions around the raising of children. Many Christian arguments against same-sex marriage concern child-rearing. Sometimes these arguments appeal to an interpretation of Scripture or to church authority, but just as often they appeal to nature. Christian opponents to same-sex marriage present scientific research to show that such arrangements damage children. Much of the alleged research comes from dubious sources. It is funded by dubious sources, and it is contradicted by a much larger and more reliable body of evidence that there is no damage to children. The citation of anti-gay research is often self-contradictory as well, because those citing it don't really believe that marriage policy should be dictated by psychological or sociological evidence. But the anti-gay science introduced into marriage or adoption debates tends to break through any utopian distinction between Christian belief and objective evidence. You cannot distinguish so easily between science and theology. Of course, you can just as easily break the utopian barrier between churches and civil governments by reversing the argument from children's welfare, to trouble the claim that Christian believers should be allowed to regulate marriages inside their own churches with minimal interference from the state. One problem with this claim is that adult believers tend to take other, more vulnerable people into their churches with them. Consider the case of those who from an early age do not experience themselves as heterosexual. Ought the free exercise rights of parents authorize them to raise queer children or adolescents under homophobic religious regimes? Do they have the right, for example, to compel the young to submit to church-run reparative therapy, to be isolated from contact with queer communities, to be damaged in quite measurable ways by years of abuse? If a state has interests in the welfare of children, let me be bold, if children actually have some rights of their own, can the state simply abandon queer children to homophobic parents on a religious plea of parental autonomy? There are dozens of similar confusions. They lead me to deny that we can easily separate churchly concerns from marriage debates, even if we all agreed that it would be a good thing. But I do continue to argue, despite the confusions, that churches and states have compelling reasons to keep trying to sort things out separately in this historical moment. Giving in to the theocratic impulses that regularly surge through churches will not only damage many vulnerable groups, it will harm all religious believers who are not members of the church that wins, and it will harm, most of all, the members of the church that wins.
Well, thank you very much. It's an honor to be on this panel. It's also a terrifying experience. I'm not a marriage lawyer at all. I'm an old fuddy-duddy legal historian, and I'm doubly terrified because this is the first time I've ever seen my dear friend and brother Mark Jordan in a pinstripe suit, and I know I'm in trouble. 10 years ago, Louisiana put in place the nation's first covenant marriage law. That law creates a two-tier system of marriage. Couples may choose a contract marriage with minimal formation steps and attendant rights to no-fault divorce, or couples may choose a covenant marriage with more stringent formation and dissolution rules. The licensing costs for either form of marriage are the same, but in order to form a covenant marriage, the parties must receive detailed counseling about marriage from a professional counselor or a religious official of their choice, and then swear a detailed oath of permanent commitment after a 6-month waiting period. Divorce has allowed such covenant couples only on grounds of adultery, capital felony, malicious desertion, or physical or sexual abuse of the spouse or a child, or after a 2-year separation. Separation is allowed on these same fault grounds as well as on proof of habitual intemperance, cruel treatment, or outrages on the part of the other spouse. Comparable marriage options are now available in Arizona and Arkansas as well. 26 additional states have covenant marriage options under consideration, Georgia included. Covenant marriage laws are designed in part to help offset the corrosive effects of America's experiment with a private contractual model of marriage. Historically, marriages were presumptively permanent commitments, and marriage formation and dissolution were serious, deliberated, public events. Marriage formation required the consent of parents and peers, the procurement of a state certificate, the publication of banns, a public ceremony, a celebration after a period of waiting and discernment. Marriage dissolution required public hearings, proof of serious fault by one party, alimony payments to the innocent dependent spouse, and ongoing support payments for minor children. In the last third of the 20th century, many of these traditional rules gave way to a private contractual model of marriage grounded in new norms of sexual liberty and privacy. In virtually all states, marriage formation rules were simplified to require only the acquisition of a license and then solemnization before a licensed official, without bans, with little or no waiting, with no public celebration, without notification of others. Marriage dissolution rules were simplified through the introduction of unilateral no-fault divorce. Either the husband or the wife could now file a suit for divorce. No fault by either party needed to be proved or staged. Courts would dissolve the union, trying to make a one-time division of marital property to give each party a clean break to start life anew. America's experiment with the private contractual model of marriage has failed on many counts, with children and women bearing disproportionate costs. Some bald numbers give us a bit of perspective. From 1975 to 2000 in America, roughly 1/4 of all children were aborted. 1/3 of all children were born to single mothers. 1/2 of all marriages ended in divorce. 2/3 of all African American children were raised without a regular male present. Mother-only homes had less than 1/3 of the median income of homes with a regular male present, and 4 times the rates of foreclosure and eviction. Teenagers who grew up in broken homes proved 3 times more likely to have behavioral learning and socialization problems than teenagers from 2-parent homes. More than 2/3, in some states over 80%, of juveniles and young adults convicted of major felonies in the past 30 years have come from single or no-parent homes. Covenant marriage laws have been one of several legal responses to these mounting social and psychological costs of America's experiment with easy-in, easy-out marriage. Covenant marriage laws reflect the historical lesson that rules governing marriage formation and dissolution must be balanced in their stringency, and that separation from bed and board must be maintained as a release valve. Stern rules of marital dissolution require stern rules of marital formation. Loose formation rules demand loose dissolution rules. To fix the modern problem of transient marriages, covenant marriage, advocates argue, requires reforms at both ends of the marital process and not just a quick fix tightening of the rules of no-fault divorce. Covenant marriage laws allow prospective couples to contract out of the state's laws of contract marriage. Couples who consider covenant marriage must fully apprise themselves of the costs and benefits of protracting the formation process and waiving their rights to no-fault divorce. But the choice of marital form is theirs. Having this choice encourages inaptly matched couples to discover their incompatibility before marriage rather than after it. If one engaged party wants a contract marriage and the other a covenant marriage when they march up to the registry hand in hand, the disparity in prospective commitment should be too plain to ignore. Couples should delay their wedding until their mutual commitment has deepened, or cancel their wedding if their respective commitments remain disparate. Better to prepare well for a marriage than to rush into it. Better to cancel a wedding than to divorce shortly after it. Such is the theory of the new covenant marriage laws. And such, in part, is the reality in Louisiana, where we have some of the most reliable data. Less than 3% of all Louisiana marriages since 1997 are covenant marriages. But there has been a notable 18% decrease in new marriage rates. Even discounting these numbers somewhat because of Katrina and lost records and the like, this is a notable shift. The virtues and the vices of this covenant marriage option we can discuss if you're interested, but we have many other good things to discuss. But in my last 82.5 seconds, I would like to suggest what these covenant marriage laws might mean for the future of family law. Some decry covenant marriage as a reversion to an old-fashioned system of marriage and divorce where parties will be trapped in marriages and held hostage to outmoded moral ideals predicated on Christian theological teachings that the state has absolutely no business establishing by law. But covenant marriage might just as well be a signpost along the way to the pluralization of marriage options held out by the state to prospective marital parties. A generation or two from now, a number of states may well be offering several off-the-rack models of contract, covenant, religious, or civil marriage or union that parties can choose, whether they're straights or gays or lesbians or bisexuals, in committed, monogamous, or polygamous unions, with or without sexual intimacy presupposed, with or without mutual dependency in property and material life, with or without non-state associations, including churches, synagogues, mosques, and temples, providing at least some of the rules and structures of marital formation, maintenance, and dissolution for their voluntary membership. Just as we have one model of marriage in most states today, each of these future off-the-rack models of marriage would have its own set of default rules set by the state concerning marital property, mutual support, custody and care for children, dependents, health and life insurance, Social Security, and all the other cool stuff Anita Bernstein was just talking about. This might seem altogether fanciful, pin-headed academics again, but in reality, the nation is already moving gradually toward this more pluralistic understanding of marriage. In Louisiana, Arizona, and Arkansas, we have covenant marriage and contract marriage options, and I suspect a few more states will soon adopt this two-track system as well. In Vermont and a number of northeastern states, we now have in place or in preparation the choice of marriage or civil union, with a variety of parallel default rules in place for the couples and for their children and dependents. In the good state of New York, Orthodox Jewish couples cannot get divorced at state law until they first get a divorce under rabbinic law, which creates, in effect, parallel state and religious laws of divorce, and by implication marriage, at least for Orthodox Jews. In Utah and other Western states with fundamentalist Mormon populations, the group that broke off in 1890, the casual disregard for open violations of state criminal laws against bigamy and polygamy by the more than 30,000 adults in documented polygamous households makes real in those states the option of monogamous versus polygamous marriage, with fundamentalist Mormon churches quietly controlling the latter. And the same is creeping into several states with rising Muslim polygamous households who so far have faced no prosecution despite their bald violation of open prohibitions against bigamy. Whether the legal pluralization of marriage is healthy or harmful is worthy of serious discussion in the years ahead, but we are moving in this direction, and more rapidly in recent years because of constitutional mandates of liberty, privacy, and equality for all. One big question for the future of family law is whether the polity is ready to accept this move formally, or if it's just going to be done by inaction, creeping onto us. If so, are there built-in stopping points in the powerful and pervasive constitutional logic of sexual liberty, privacy, and equality for a state to support only some types of voluntary intimate union beyond heterosexual monogamy, but not other types? Once you take that first perilous step on this slippery slope of marital pluralism, will you inevitably slide all the way down? And what lies waiting there at the uncharted bottom of the hill, especially for young children, for the needy, for dependents? Are we sliding into a Hobbesian state of nature, where life is brutish, nasty, and short? Are we slowly moving toward a great democracy of desire? Are we slowly realizing, finally, liberty of intimacy and intimate union for all, without interference by church, state, society, or neighbor?
Thank you, Professor Whitting. Professor Worthington?
Thank you. It's rare that I would get in the last word in a group like this, so I'm appreciative of the alphabetical ordering. The question of what rights children should have in the context of divorce, marriage, and family is an important one, but it is a conclusory question, one that should be asked after an exploration of the nature and role of children in society. The legal system interacts with children in many ways, and the rules of those interactions are often based on the context in which the child encounters the legal system, rather than on a coherent approach to children based on a universally accepted paradigm regarding children's place in society. The discordance in the law's approach to children can be seen in one brief example. Today in Georgia, a 13-year-old could be tried in adult criminal court and be sentenced to serve a life sentence without parole. But that same 13-year-old cannot drive, cannot vote, cannot enter into a legally binding contract for most things, cannot consent to most medical care, and cannot enter into a marriage. The 13-year-old can, however, bear a child and assume full responsibility for all decision-making regarding the infant. There are sound reasons that children are treated differently in different contexts, but the existing patchwork approach to children in the law is not grounded in knowledge about children's differing capacities and capabilities in disparate contexts. Instead, it is a result of a large-scale failure of the legal system, and more importantly, the country, to engage in an honest, thorough, and public discussion about the paradigms through which we approach children as a concept and as individuals. It was not long ago that children were treated as the property of their parents, and legal issues concerning children were approached from the perspective of property and contracts. Throughout this country's history, large segments of our population have approached children from a religious perspective, using the Bible and other religious texts as the ultimate authority on the handling of children. More recent approaches have used a rights-based analysis, examining the extent to which constitutional and statutory rights apply to children, or have used a human rights approach, contending that all human beings have inherent rights, irrespective of their ability to independently assert those rights. The disciplines of psychology, social work, and education require that any approach be grounded in evidence-based child development research. One possible framework for approaching children would be based on stringent scientific and social research regarding what ingredients or life elements optimize child well-being. If such an approach were taken, the discussion tonight would be about covenant parenthood and perhaps reorganizing the allocation of resources so the benefits that are currently attributed to households led by two biological married parents could be dispensed to all children based on individual needs. Because our country is not quite ready for such a radical approach, we instead resort to discussions that fit within existing paradigms, hence the use of a rights framework when discussing children within marriage and divorce. I believe that one reason the children's rights mantle is often donned by those advocating for children's well-being is because adults as a society do a poor job of maximizing the well-being of all children. Historically in the United States, the disenfranchised, the vulnerable, the voiceless have been empowered through the conveyance of rights. So a rights-based framework to bring about better outcomes for children is one that has historical precedents and models. A rights-based approach is one way to try to force adults to honor their responsibilities and commitments to children. Of course, these statements are somewhat circular because the next logical line of discussion concerns what parents' and society's obligations are regarding children and to what extent rights can be or should be conferred on children because of an adult's duties. And unfortunately, as much as I would like to, there is not time at this moment to dive further into that discussion. One thing to consider as we continue to wrestle with questions of parenthood and childhood, and as we hopefully move toward a suitable paradigm for approaching these discussions and policy decisions, is what to do in the interim. Children live in the present, and our laws and policies must be mindful of that. Currently, the child's best interests is a standard used in many aspects of family law and children's law. In my opinion, it is discussed by many and understood by few. We presume that parents act in their child's best interests and are better able to determine what is best for the child than either the state or the child. We too rarely get the child's perspective on situations. As scholar Barbara Woodhouse has said, the law tends to displace the child's concrete experience of care with an adult's abstract conception of right. An alternative to the best interest motto was proposed many years ago and is still valid today, particularly in the dysfunctionality of many families and systems serving children. Joseph Goldstein, Albert Solnit, and others used a multidisciplinary approach to arrive at the standard of the least detrimental alternative for safeguarding a child's growth and development. This standard recognizes that detriment is inherent in every placement decision. Once there are questions on the table about where and with whom a child will live, some damage has already occurred. One responsibility of adults is to mitigate that damage. The least detrimental alternative standard is based on 3 guidelines. Placements should safeguard a child's need for continuity, reflect a child's sense of time, and take into account the law's incapacity to make long-range predictions and manage family relationships. Under this standard, the goal of placement decisions should be the specific placement and the procedure for placement, which maximize a child's opportunity for being wanted and for maintaining on a continuous, unconditional, and permanent basis a relationship with at least one adult who is in fact or is capable of becoming her psychological parent. I believe that children deserve so much more than this least detrimental alternative. But until we are willing to radically change our perceptions of parents' rights and responsibilities and grant children the power to help shape policies that affect them, it is a standard to consider. And if nothing else, the stark reality of this standard may help prepare adults for the day when we need to listen to the voices of children who will not hesitate to point out our shortcomings in creating a world fit for them.
Thank you to the panel. We will be taking questions, and toward that end, there are microphones on both sides of the room. Before we do so, however, I wish to pose the following to the panel. There is a predominant and perhaps powerful sociological view that children prosper in intact families. To the panel, if you agree that this is the case, what role should the state or religious institutions take in promoting that point of view? If you disagree with the premise that children prosper in intact families, why? How do we define intact families, and why do we do so? And should these definitions change? Panel? Volunteers? Professor Bernstein.
You may have offered us what Karen has just called a conclusory question. I think there's an assumption embedded in there that I'm not comfortable with, which is that we should try to put children in a preferred category as if they were competing side by side for recognition as better off. The old-fashioned liberal view that I favor would look for welfare across the board and try to give children the conditions they need to prosper in an absolute way, rather than to make them better off in contrast to those in non-intact families. But I don't want to dodge, so let me say, I think the answer to whether children prosper in intact families is something like no and yes, or yes but. And that is, the problem is the wealth effect. Couples that are wealthy are much less likely to get divorced, and children in prosperous homes with money, I mean not emotionally prosperous, but financially prosperous, are more likely to pass through various markers in the correct way, in the approved way, than children from poor homes. It's really hard to control for lack of money because, much as I might like to, you really can't randomly sort children into intact versus non-intact households and then see how they do a few years later. So all we can do is look to see whether the children who fall into various pitfalls or various plights come from the households where they're living with both parents who are still married to each other. And it's really hard to separate out the effect of money. To complicate it further, a man who is living with the mother of his children is likely to be favored by his employer and to make more money. And so I don't really know how to deal with that very well documented fact in trying to figure out the welfare of children, because it may be the intact marriage makes him in fact a better worker, maybe alternatively his boss is prejudiced in favor of married men and against people who are not married men. And finally, and this, I think you touched on this, John, I'm not sure we know what we're talking about when we say children of intact families prosper. The researchers don't agree on the markers to look for. You mentioned, or rather, John Whitty mentioned not getting arrested and not acting out, and that's one way to look at it. Graduation from high school is another. But there's a certain dishonesty in the research project that doesn't agree in advance what the variables are and to live with the results even if they're embarrassing. So I think we're not yet ready to say that children prosper in intact families as a reason to insert the heavy hand of government in encouraging marriage.
Other takers?
I'll just say one P.S., and that is the real difficulty of deifying the biological family and insisting that children whose life and limb have been imperiled by their natural parents nonetheless need be returned to those natural parents. And I have a lot of trouble with that, even though the alternatives are probably equally grim, and my distinguished colleague, Professor Worthington, can give us statistics on that. I do worry about the extraordinary celebration of biological family values and the necessity of having a biological contact or genetic contact between the caregiver and the child. As a proud father of an adopted child, I can tell you that biology has very little to do with true parental love or the benefit of being loved by a child in return.
Other comment? Questions? Let me pose, and yes, sir. I guess he was scratching. Let me pose this question. Does understanding that historically we understand that the states and not the federal government, I'm sorry? Oh, there is a question. Go ahead, please, sir. There's a microphone right there.
Anita, I've heard you talk about this a couple of times. I think I've read the original paper, and I still don't understand. Are you proposing that folks who want to get married should go to their respective religious institutions and make whatever arrangements these institutions propose, and if they don't want to go to a religious institution, they should just agree to live together, and that if they want to break up this union, they should go back to their religious institutions and break them up on whatever rules the religious institution sets, and if they don't belong to a religious institution, they should just kind of work it out between them, and that the state should neither recognize these unions, even if they recognize them de facto as established by somebody else, nor should the state recognize their dissolution de facto. And if that's what you're proposing, what do you do when there's a difference of opinion between the couples, or between the members of the couple, or between the couple and the institutions or non-institutions? I mean, somewhere you've got to be able to regulate conflict in dissolution. Somewhere you've got to be able to regulate rights, if that's the word, or protect in some way children of such unions. And I don't see how you can possibly have either marriage or dissolution of marriage without the involvement of the state or the court system.
No. I did say that in 2003, but we've moved along. So I guess, David, my response is that something like what you described, or perhaps less amusingly, in a duller way, is the abolition of marriage thesis. I guess I'm not sure I understand why you think it is this incoherent. The idea is that when people present their disagreements to the government or to some legal decision maker, they are treated as if they were not unified or moved into one before the onset of the disagreement. The idea that I was floating today is not to abandon recognition of marriage, but to make the status of being married less determinative of particular government-sponsored outcomes and less likely to make a difference in the amount of money that you have. So I'm proposing weaken it, maim it, but don't abolish it. That's the idea that I wanted to talk about tonight. I also think, though, that the problems that you present, a disagreement, it can be easily worked out. One person in the couple says, I think she's my wife and I think I get X, Y, Z as a result. And the other person says, you're delusional, there was never a marriage. Courts handle that kind of problem in different ways all the time. And the metaphysical question of whether marriage is possible, I don't think inhibits courts from adjudicating disputes between people.
Other comments on that question?
I wanted to speak up is this on? I just wanted to mention, couple that question and Anita's response with the question before, that in the research looking at whether married parents or intact families, however you want to define it, are better for children, the one experiment we have not done in this country is unbundle the supports that flow to married families from the concept of marriage. And our own Martha Feynman has done a lot of research and work around using a dependency model, whereby moving around social goods and moving around economic supports and other supports within our social structures could perhaps provide the same supports for children that would result in the same outcomes, even if they weren't in two-parent married families. And that's something we haven't yet done in this country.
Let me follow up on that a little bit. The question is posed as to whether the state has a legitimate interest in the promotion of marriage. Is there a public policy that states have that we can discern that we think are defensible? And how are they expressed? Ballot initiatives, by the judiciary, or in legislation? Would anybody care to comment on that?
I could just say a brief word as a legal historian that marriage has principally been an issue at the state level rather than at the federal level, has been an issue of common law, not of constitutional law. And where changes are made in marriage and family, they are made by long-standing legislative deliberation and not by constitutional amendment. And I think the interesting new involvement of the federal government in the passage of the Defense of Marriage Act, in the proposal for a constitutional amendment to define marriage in a given way, is a form of constitutional brinksmanship in violation of the very federalist premises on which the government has many of its other policies predicated.
Other comment? Is marriage now an ordinary contract? That is, it is a contract with the state, is it not? Is it an ordinary contract, one that is freed from public policy considerations?
try again. It's the great Joseph Story, the greatest American jurist in the 19th century, said marriage is more than a mere contract. Of course it is a contract. Of course it is based fundamentally on the mutual consent of the man and the woman, each of whom have capacity and fitness to enter into the union, each of whom enter into the union voluntarily without duress, fraud, or any kind of impediment upon their choice to enter the union with all of the attached benefits. And marriage in that sense is very much a voluntary bilateral union like any other. But marriage is more than a mere contract. Marriage is also a symbol of a variety of things. It is a symbol of a set of relationships that go beyond the individual couple. It's the symbol of continuity in the process of families being transmitted to a next generation. It is the channel through which we pass on names, through which we pass on property, through which we pass on lineage. For some people, it is also a symbol of the divine, a symbol of the relationship between Yahweh and his elect nation of Israel, a symbol of Christ's relationship with his church. Even if one doesn't necessarily buy the theologically laden language of symbolism, within the polity itself, it is recognized to be a special contract. It is recognized to be something that is ultimately more than just the couple coming together. And we have that in all manner of metaphors that the Supreme Court and other high authorities have used in the tradition about being the cornerstone of civilization, the pillar of society, and the like. All of these may be interesting hackneyed notions that have now dissolved away under sociological data, but there is something fundamental in that contract that has historically always been recognized to be more than simply a bilateral exchange. And amongst the ways whereby that symbolism is underscored is that this is an adhesion contract, as we lawyers say, that the freedom to enter and freedom to exit is guaranteed, but the terms of the marital contract themselves are not negotiable. That is, the form and the function of that unit are preset by the state, and the couple has the opportunity to accept or to reject, not to renegotiate the internal terms of that contract. And it's akin to when you go to Sears and you buy a stove. You have a 30-page contract, and your opportunity is basically to sign or not sign the bottom of page 30. You don't negotiate the individual terms. And in some sense, marital contracts are the same way. The terms are preset. And when we don't, if we make them negotiable, that becomes the dissolution of marriage into a mere private contract, which for some people is troublesome, for other people is the necessary move that we have to endure as a society in order to ultimately achieve true freedom.
And of course, we can take the stove back if it's not working correctly. Yes, sir.
I can perhaps take this one at least a few paces, David. Because also in Europe we have, just now the 7th anniversary of the French law on the Pax, the civil association that permits same-sex couples to have a form of civil union. I think the sort of issues that John raises are in fact better addressed by a stricter separation of civil marriage and church marriage. I think that the deeper values which differ by religion are better preserved and protected if they are not entrusted to the state to enforce them. And I think it's certainly the case that Christian churches would be better off in their marriage theology and their practice of marriage if they had kept a greater distance with respect to state institutions and retained more of their liberty to exercise their own notions of what marriage should be. So that kind of dual system seems to me to have much to recommend it, precisely in view of protecting some of the deeper reserves, symbolic and sacramental, of marriage.
Professor Shapiro.
Thank you. guess we're reflecting tonight a bit on the relationship of the state and of marriage. And I was interested in the views of the panelists, I suppose, on their views of how strong the effects of law are on the actual shape of social arrangements that we see. I was thinking a bit of the Goodridge decision where the Massachusetts Supreme Judicial Court said that there would be same-sex marriage, and there the dissent said, well, the legislature might rationally decide that children prosper best when there is a man and a woman, so it's appropriate for the legislature to say no same-sex marriage. Whereas the majority said, if people want to engage in same-sex unions, they're going to do that. That's not what the question is. The question is whether the children of those same-sex unions will actually be in a marital relationship. That is, the majority seemed to say there was a fairly limited role of the law in shaping the way that people were actually going to live. So take it, part of the question is it appropriate for the state to try to shape people's social arrangements through marriage laws? And another question I'd be interested in hearing your reflections on is it effective for the state to try to do that?
Pam?
One effect of the court-fueled legal change that you refer to is the lack of shock effect, the kind of deadening of the senses. And I'm thinking in particular about Vermont's decision, Vermont's Supreme Court's decision in 1999 to mandate civil unions. This was considered a momentous, shocking decision. Careers were in jeopardy. Howard Dean thought maybe that would be the last we'd see of him. And since then, because of the existence of the later case that you mentioned, the Goodridge case of 2003, the public is no longer aghast at the thought of extending many privileges to same-sex couples. That is, I think, one of the stronger claims one can make for the idea that courts in particular and law in general shape public attitudes. But I think, I suspect, I can't really prove it, that these changes do affect consciousness and the stances people take.
Other comments? Question over here. Do you mind moving to the other microphone? We know it's working. Thank you. Speak up a little bit.
It's very nice to see you've got a very nice audience here. It's good to see a lot of people that are interested in the future of marriage and family life. And I apologize, I came in during Professor Jordan's presentation, so I didn't hear Professor Bernstein. But I was going to comment on Professor Jordan's. I did have a kind of a
Question?
gut felt instinct on that. Yeah, I have a question. Professor Jordan argues that same-sex parenting research presented by Christian believers is dubious or funded by dubious sources. Adult believers take in more vulnerable parties. You referred to homophobes. I guess I kind of took your comments for what I heard of them, if you know what I mean by anti-Semitic. I took them to be anti-Christian, very generalized, stereotypical. But I suppose your conclusion was that churches and state need to sort out same-sex unions separately. And of course, I'm sure you recognize the distinction between individuals and the institutions of state and church. So I'm sure all of us, or probably all of us, are citizens to whom this government is accountable, as well as maybe a few of us or many of us are members of a church. But by exercising our views at the polls or what have you, is not in itself now a clash or a collusion of church and state. Would you agree?
Would you restate the question? Is the question related to whether a ballot initiative recognizes a clash between the church and state?
Well, what I heard was a talk about Christian believers, and then that the institutions of the church and state should sort out same-sex unions separately. And I'm wondering how that is not being done separately when individuals who may be members of a church but are also citizens, what's the conflict whenever they vote on the kind of amendments that have been voted on around the country, state by state, on the issue that you spoke of?
There's no conflict. I mean, in the sense there's no prima facie inconsistency, and I suppose from the state's point of view, certain votes that are cast might be considered to be unwise or not for the common good. But certainly people have a right to cast them. But I was actually making a prior argument, which is from the Christian point of view, first, that there's an enormous diversity of opinion among Christians about this. Second, that I believe that the attempt to legislate, I'm speaking now as a Christian and as a professor of Christian theology, I believe that the attempt to legislate peculiarly Christian views in a pluralistic, religiously pluralistic democracy is not only bad for the democracy, but bad for Christianity. I think it damages Christian churches to attempt to exercise that sort of power. And if Christian churches are unable, by the force of example, by preaching the gospel, to attract people voluntarily to adhere to their beliefs, then they ought not to resort to this power of the state in order to legislate them. So that was really my prior point. And I hope I was actually thinking of very specific cases when I was talking about the plight of non-heterosexual children being raised in very particular church circumstances. My whole point is that there's an enormous diversity in Christian churches and of the situations of people within them. So I hope precisely not to be doing a kind of monolithic depiction of Christianity. I think part of the problem of our current debates is precisely the representation of Christianity as a monolith, when clearly it's not.
Well, could you clarify, I'm sorry, then I didn't understand, what exercise of power you caution Christians against? It's not voting, I suppose you mean. So what? It's the wisdom of voting. I mean, it's not, when people say they want to vote their convictions, it seems to me one always has to ask the question first, whether it's for the common good of the state of which one's a citizen, even as a Christian, but second of all, whether it's for the good of the church to attempt to impose its views, not by preaching, not by attraction, not by the shining example of the light on the hill, but by a majority vote, precisely against, I might say, other Christian views and the views of other religious traditions. Okay, so because if there's a diversity in the church of opinion, then we should wait till we're all on the same page and then all vote together, or, I mean, I'm still not, I thank you for addressing my question.
And let me say this too, I mean, just so we're not limiting ourselves, and I understand the qualifications you gave, Professor Jordan, but we recognize the diversity in opinion in synagogues and other religious institutions as well, and those precepts apply in a similar way, do they not?
Oh, absolutely.
Not meant to limit this to Christianity. The diversity is in other institutions as well.
Well, thank you. And one other comment, just as far as children prospering in intact families and the question that you posed, which I think was a very good question, Mr. Mayhew, and how do we encourage that? Obviously, I think that's a question that is really hard to answer, but I think intact families are generally thought of as being mom and dad are home together as far as looking for a definition. And prospering, you know, kids just doing well in school and having good relationships. And whether or not there's a cause and effect, I think maybe the common wisdom is that there is. And our enchantment with biological mothers and fathers is just that that's how most of us, if I suppose all of us, got here. So we're just kind of enchanted with the idea of the biological mother and father. And so that might be one reason that we look to that as the natural role model.
Comment on that? Professor Whitty?
I don't want to comment on that last point, and with respect for it. I actually wanted to play with your first premise of your first question and just ask my distinguished colleague, Professor Jordan, of what the state of the social science literature actually is, charged or uncharged by ideological presupposition, on how children, on a variety of indicators, do in same-sex and other sex households. Do we have good longitudinal data now at our fingertips? Because that is one of the big bones of contention amongst those that are pro and anti same-sex marriage. The open question being whether children born into, adopted into, or brought into that union are in point of fact given the same fair shake that children in traditional heterosexual households presumably have. And I think that is the issue, and the hard question becomes, is it appropriate for us to indulge a 20-year experiment using children who do not volunteer for this experiment? Is it appropriate for us to put children through those paces when the data themselves aren't necessarily going to give us a preordained result? And I guess it'll be interesting to hear that, and I guess we got enough studies now that we probably have some sense of that. I don't want to put you on the spot, but I think that is a hard issue that we probably have to wrestle with.
Let me say three things to it, John. First, I in general do not trust sociological studies, any sociological studies. They are very blunt instruments to measure human happiness, and they are at best give you statistical generalizations when human lives are inevitably particular. Second, in a survey of all scientifically reputable studies done of children raised by same-sex couples, gathered by the American Psychological Association, the result of all these studies, there were almost 60 of them if I'm remembering correctly, was that there was no negative impact on children, and that there was a slight positive impact of children raised by lesbian couples in comparison with heterosexual couples, which I take it may be a remark about gender differences. My third point is that here I can only draw a comparison which is difficult for many people, but if we do find negative results, or if we do begin to wonder about exposing children to the damage done to them in a homophobic society by being raised by same-sex couples, it seems to me to conclude from that we ought not to let same-sex couples raise children, because after all, it's a homophobic society and their children are going to be exposed to greater damage, is about like concluding in 1945 that we ought not to let African Americans raise children, because after all, African American children are exposed to greater damage in a racist society. The solution is not to stop people raising children, it's to change the society.
Other comments from the panel or questions? Yes, please. Do you mind taking the microphone over here? Thank you. Oh, good.
Does it work? Okay. All of you have talked about the changes over the last 100 years, last 50 years, last 30 years, and most of those changes have been an enlarging of the possibilities, an enlarging of the definitions of family and people's options in terms of making families and making choices about their own lives. But boy, my ears perked right up when Professor Worthington talked about covenant parenthood. Is there any discussion among scholars, among anybody, about any way there is possible in the world to at least give people some training, get a license, do something before they're permitted to have children?
What would the license requirements be, Professor Whitty?
If I could write it. What I said is if I could write the licensing requirements. A lot of my work deals with abuse and neglect. I am not the constitutional scholar on the panel, so I have not studied heavily all the constitutional implications of such an argument. But one premise that's on the table is if we are starting to discuss as a society sort of dabbling with the rights of intimate association with regard to marriage, how far a leap would it be before people started making the arguments around parenthood? Could we possibly regulate that under some kind of scheme that bore out to be constitutional over time? And I don't know the answers. But if you look at some of the justifications for looking at marriage laws in terms of societal goods, etc., when it comes to children and the outcomes on society of bad parenting, there's a whole lot more persuasive argument. But I'm going to defer to our constitutional scholars over here.
I know just enough constitutional law to get through 14 weeks in the first semester, and I run out the last 45 minutes. I can't speak to the constitutional question. I do want to mention a few interesting fringe developments in a number of states now about children suing their parents for a number of different causes of action, for chronic neglect and abuse. In a couple of instances, illegitimate children who are abandoned by their parents, suing for reformation of inheritance, last wills and testaments, and other instruments, seeking to recoup from the estate funds that should have gone to them. The ability to make greater decisions, to have greater rights to make decisions in child custody when a child reaches an age of 12, 13, 14, 15. These are all tacit endorsements, on the one hand, of what Professor Worthington pressed, which is the importance of children's rights, which is not something that is said politely in American society, but nonetheless is a very important development in many parts of the world and is creeping in through other terminology here. And at the same time, it is also provides a few stepping stones toward realizing the benefits of what in full orb terms would be an understanding of a covenant parent contract that a parent would have with a child, and it would be implied by the very conception and raising of that child. So I think this is not quite as fanciful as it might seem, and there's enough traction available in cases, to be sure, yet at the edges of tort and contract jurisprudence that might point to a better way with respect to children, especially those abused, neglected, forgotten.
And of course, the licensing question becomes more immediate when you consider artificial reproduction technology and the creation of designer children and designer embryos. It was reported last week that there's a firm in Texas that is now selling or attempting to sell human embryos. What kind of requirements would we have for the purchaser? More than the Sears stove, I would think. Other questions? Yes. Yes, please do.
One of the areas when you talk about children's rights is one of the questions is from where do children's rights flow? And I touched on that a little bit. Is it statutory and constitutional? Is it inherent based on human rights doctrine? One of the most common analyses of rights is they flow from duties of other people. And in this country, it's pretty commonly understood that parents have certain duties to their children, and we have an entire statutory scheme set up, the child welfare system, to begin to take steps when parents do not comport with their requirements, their duties, to provide adequate care for their children. So the UN Convention on the Rights of the Child, which has been a subject of much debate in this country, the perspectives on whether that might be a good thing for children or not, and a good thing for this country or not, may depend in part on what your perspective is on where rights flow from and what can be done with it. So in many countries, it is used for children to protect their rights to duties and obligations that are owed to them in terms of health, education, food, shelter, clothing, and other things. In this country, I believe there are a lot of misperceptions about the fact that, oh, children can now sue their parents. And that language often raises into headlines. But when you look at the story behind headlines such as child sues parents, it's generally to have the child receive a benefit that either the state or the parent owes, such as in the state has an obligation to protect a child from abuse. If the state does not accept that obligation, does the child have any other recourse? And those are a whole lot of areas to explore when you start to talk about children's rights.
Professor Bernstein?
If I could add a word on covenant parenthood. We don't have licensing, it's true, for baby making in this country, but to the extent we do have covenant parenthood, it's going on in gay and lesbian relationships where one does not become pregnant by accident and the child can't be begotten without a lot of care and planning. The studies to which Mark Jordan referred about the better outcome of children who grow up in gay and lesbian households, and I too am very skeptical of this sort of research, as I said, might reflect in part the deliberation and thoughtfulness that necessarily has to precede the formation of the child.
Other comments? Questions? Sheil?
Thank you, John. I'm a local divorce lawyer who's been in the field with John for a long time, and I like the panel's comments on what's happening in the courts, for example, in DeKalb County, where parents can agree on how custody should take place. Yet, under Georgia law, the judge can accept or reject in whole or in part their agreement, thereby the state now having authority over the rights and responsibilities of the child for custody and for visitation. And a court can reject the parties' consensual agreement on how they wish to go forward. For example, joint custody, equal time. If a particular jurist does not believe that's in a child's best interest, they can reject it and impose whatever rights, any responsibilities, any system, any schedule they want. I'd like the comment of the panel on whether the law of the state supports the best interests of the children under that theory.
Any takers?
It's a broad question. And I always stand by the fact that the best interest of the child determination is always going to be individual. In the cases where you're talking about, generally when two parties enter into a contract voluntarily, they can bind themselves. And what you're saying is that in DeKalb County in practice and under Georgia law.
In Georgia law,
right.
that agreement may be rejected, and a new law, a new schedule, a new policy can be put in place despite the parties' agreement.
Exactly. One of the difficulties with dealing with children is many decisions depend on individuals' perspectives on that situation. And there can be many appropriate perspectives on a situation. Those parents might have decided what they feel is appropriate, and for whatever reason, a judge could make a different determination. Part of that goes towards people's individual views on whether you should be able to make those kind of agreements without state interference. Some would say that by entering into a legal marriage, it's a contract over which the state has authority. You have to agree to follow the state's rules to enter into the marriage and to divorce, and therefore when you enter the marriage, you should know that if anything happens, it's not entirely up to you. There are other parties, and most significantly the state, involved in the dissolution.
The only thing I would say, I share your skepticism about the wisdom of putting that in the hands of a judiciary that is overtaxed with a very swollen divorce docket and oftentimes is making reflex decisions. I do think it's stepping back a bit, as Professor Worthington is intimating. It is important to have an objective, to the extent possible, third-party look in on this, because in a divorce context, it is not an arm's-length rational bargain between two equal parties. These are bruised parties operating often with highly charged emotions, whose interests and whose concern for the interest of their children may be skewed by the desire for immediate relief from continuing in the relationship or the negotiation, rather than making a protracted assessment of what the needs of the child are and judiciously attending to those needs. And in that sense, a simple rule of unconscionability only being a sufficient ground on which the state can intervene, or judiciary could intervene, I think would be too frail a protection for the interest of the child. But if it is simply a capricious power given to the judiciary to unmake months of careful negotiation between parties, in which the children, especially as teenagers, might be involved in decision-making, I would find that abominable.
Questions, sir?
Yeah, I'd like to return to the marriage idea. 2 years and 2 months ago, this state voted a restriction on gay marriage. And I'm interested in knowing how the legislature could throw it on a vote when the Constitution of Georgia says that no laws shall be made which restrict religion. And the UCC Church, the Episcopal Church, several branches of the Jewish churches, MCC, UUs, would marry same-sex couples. So what is the legality with a statement like that in the Constitution?
Any takers?
This is my question.
If you have a constitutional text that has two conflicting provisions, the issue is how you resolve that conflict. And if you have one provision that says there can be no establishment of religion or prohibition on the free exercise rights of individual citizens or groups, and another provision that sets limits to what is considered to be appropriate conduct regardless of which party does it, the canons of interpretation of the Constitution would say that parties have the free exercise rights to practice all of the things that are permissible on religious or non-religious grounds, but they cannot have the free exercise right to engage in illegal conduct. There is no free exercise right to engage in a crime. There is no free exercise right to engage in unconstitutional conduct. And so an argument that says there is a free exercise right to be excused from a constitutional amendment or a criminal statute is a no-starter in American jurisprudence. The harder question is whether it's appropriate for a state to put in place, as Professor Jordan was pressing, for the state to put in place an understanding of marriage overtly predicated on a given religious argument. And that becomes harder if it is done by legislation, and the legislation is cast quite overtly in religious terms, and scripture is adduced, and hymns are sung, and churches are brought in, and much orchestration is done on overt religious grounds to give rise to that particular formulation at law of what marriage is. That is a patent constitutional violation of the Establishment Clause of the First Amendment and of individual state constitutional provisions on point, including in Georgia. The harder question is advised by a clever counsel like Anita Bernstein or others, or Karen Worthington, when a state legislature puts in place a law with respect to the definition of marriage that is consistent with, consonant with, prevailing Judeo-Christian or particular forms of Christian understandings of marriage is the very presence of overlap between a theological definition of religion and the legal definition of religion that is chosen by the legislature, is the very presence of overlap, prima facie, a constitutional violation of the Establishment Clause. And under current constitutional jurisprudence, the answer to that is no. And what the irony of all this is that it's clever lawyering, much more than substantive decision, that is driving the decision as to whether there's an Establishment Clause violation. And that's the hard one. It really is the hard one.
We'll take two more questions on this side.
Thank you. Good evening. My name is Rashay Janine Daniel Barnes, and I'm a doctoral candidate in the Department of Anthropology here at Emory. I do my research with African American families, and my question is particularly about one of the questions that was raised earlier about parental contracts or parental licensing. And I have a comment and a question. The comment is that I'm very concerned about parents and families neglecting children, but I do want to remind us that we have had a history of trying to control the reproductive practices of certain populations. And I think it would be very important for us to remember that we need to take into consideration some of the ways in which we define good parenting and be mindful of those types of things when we are constructing policy or advocating for children and for families. That's my comment. My question is related, and since I do work with families, I am particularly interested in I guess going back to something Dr. Worthington was saying, was children need our assistance now. They're living in the now. And so we can talk about how the state may need to remove itself from its very focused attention to marriage. But how do we, in the now, advocate for children when children are encompassed in families, whether those families are married or not? How do we advocate for children in a healthy, supportive situation without advocating and supporting marriage?
Professor Worthington?
Thanks for your thoughtful comments. I'm thinking for a minute. There is a lot of research that shows that children fare well in two-parent families. There's also extraordinary research out there from hundreds of years that shows that children do well in a variety of situations. And people who are concerned about, you know, who's going to be taking care of the country when all of us are well beyond our 80s, need to be thinking now about how are we protecting and nurturing the youngest of us. And looking out for the welfare of children takes into account, and welfare in the broadest sense, the child's sense of family and community. So for a lot of people who work with children, the perspective is who is and what is important to that child. From a child's perspective, from a young child's perspective, it changes. I mean, children, one of the difficulties with working in children's issues is they change so much so quickly. But particularly with young children, blood is irrelevant. I mean, a parent is the person who provides security, food, nurture, and stability. And there needs to be no biological or legal relationship. So for those of us who are concerned particularly about the youngest of children, it's a focus on protecting the caregivers of the child who are providing appropriate caregiving, and that's a very loaded term, the appropriate, but you can take that down to the most basics. As children get older, I mean, as a community, as a society, we know some of the things through clear research that provide good outcomes: education, healthcare, nutrition. I mean, there's some very basic fundamental things that there is not an argument about. So one of the things to look about, which is why I kept going back to how we allocate social goods in the country, is there a serious enough commitment for future generations to really question how we're allocating resources so that benefits don't flow to children based on legal or biological relationships, they flow on need. And those are some few things I can offer there.
Last question.
Hello. Dr. Bernstein mentioned she was discussing whether the government should be encouraging marriage, but my question is whether you think that the government and public policy, even sort of the public consciousness at large, is operating in an outmoded version of marriage and what American sexuality and family life is like, given that most families are not traditional nuclear families. I think recently in the Times an article came out that most women are not spending the majority of their lives excuse me, in marriage. So I was wondering if you think that the government, the legal system, society at large are actually operating with a notion of marriage that is no longer applicable.
That's an interesting flaw that I did not mention, but want to kind of repeat and emphasize that there's some, I guess I would situate your comment in a larger confusion about what it is we're trying to promote. I think the marriage promoters do have good intentions, and there's kernels of truth in their contention that encouraging marriage will yield to more prosperity. But in addition to what you raise about the uncertainty about who exactly we're talking to, I think it's difficult to actually encourage through law or policy the decision to marry or the decision not to leave a marriage that one is otherwise inclined to leave. The tools are pretty sparse. We don't really have much to work with. The government could promote marriage. It could sort of put the good news, spread the gospel. This will make you happy. This is a way of life that you'll be glad that you did, and you may not really fully know that before you start it. But it's hard to know what they would say specifically about these goods of marriage that would be accurate and interesting. There are goods of cohabiting. That you save money on appliances. You don't have to primp to obtain sex. You know, but that's not marriage. That's living with somebody. There's the wealth effect that I mentioned, which is just completely a confounding variable. It's possible people will make more money when they're married. Possible that it won't. There are goods of marriage that are sort of embarrassing and unpleasant to hear, such as you're likely to have more money when your husband dies based on his income, or you will, in the event of a breakup, you'll get more money than you would if you were merely cohabiting. True, but unpleasant, and therefore not part of a good, effective propaganda campaign. So I think the government really doesn't quite know what it can do in order to promote marriage, and the point that you raise is one of several troubles, of several difficulties with the idea of the rhetorically attractive plan of promoting marriage.
Professor Whitty?
I'm changing hats from a happy panelist who's learned a lot to the director of the center, which has sponsored today's event. My tasks are very happy ones that I'll take 82.5 seconds again. First of all, to extend several rounds of thanks. First and foremost, thanks to all of you for taking the time to be with us this evening and to be part of this lively discussion, which I hope we can continue in a number of contexts going forward. I want to thank my distinguished friend and colleague John Mayu, and my distinguished colleagues on the panel, Professor Bernstein, Professor Jordan, and Professor Worthington, for enlightening us as richly as they have this evening. And I think those of our colleagues need a very robust round of applause for their fine work. The Center for the Study of Law and Religion operates only because we have a fabulous staff whom we call the Dream Team, who do all the choreography and all the background and all the preparation for these kinds of events, put together the materials. And I'd like to invite your recognition of the 5 members of the Dream Team, whose handiwork, again, we've enjoyed this evening: April Bogle, Eliza Ellison, Anita Mann, Amy Wheeler, and Janice Wiggins. If we could recognize them, please. If I could commend to you this form interior to your program that invites you to give us your comments. These are very helpful responses from you to give us a sense as to how we are reaching you, whether we're effective, what we can do differently in our fora to make them more attractive to you. It would help us a great deal if you could just take the moment to fill these in, give us your name and address, and let us have a way to reach you again so that we can invite you back to future fora. I do want to underscore a forum that's forthcoming 12 days hence on January 29 in this same place, Tall Auditorium, at 4 p.m. rather than in the evening. It's the Curry Lecture in Law and Religion, and it's by our distinguished Candler Professor of Law, Professor Abdullahi An-Naim, who is a fierce and courageous Muslim advocate for human rights and reform within his own Islamic community. And his lecture is going to be on secularism from an Islamic perspective, and it promises to be an extraordinary presentation with plenty of opportunity for Q&A with you, and we would commend that forum very much to you and hope that you will come back for it on January 29. I hope that after this forum you will also take advantage of the various pieces of literature that the Center makes available to you. Please take those along. There are a number of books by my distinguished colleagues out there with flyers that can be taken along, and books ordered for your further edification. I want to recognize a sad word of remembrance for our departed brother, Robin Nash, who is the person who should be sitting on this panel, certainly instead of me, and whose loss is acute to many members of the community, especially to my distinguished colleague, Professor Worthington, with whom he worked very closely, and we remember him in prayer and with thanksgiving for all that he did tonight. And on a far less somber note, today is Anita Bernstein's birthday. And so happy birthday to Anita. Happy birthday to you. Happy birthday to you. Happy birthday, dear Anita. Happy birthday to you. It's the first time I've ever seen Anita Bernstein blush. Will you join us in a round of cake and a round of various wonderful foodstuffs that we have outside for you? Thanks so much for being here tonight.
The preceding program is copyrighted by Emory University.